I was elected in January of 2012.
Okay.
And so I would say in the time that I've been on the bench here, which has been less than even 3 years now, I've certainly seen somewhere near a couple hundred cases, and we can probably get a closer estimate if we just look at our database here.
Mm-hmm.
But we definitely see several per month and per week.
Could almost be several per week.
Yes.
Several per week.
In some form or another. And if it doesn't manifest in the form of a traditional, let's say, domestic violence case, it can come in the form of a menacing, which involves the same individuals. And again, if you just sort of understand some of the touchstones of the violence, or where some of the cases sort of begin, or some of the signals that begin to identify maybe the toxicity that may give you some idea of what the relationship looks like before it becomes the traditional domestic violence case. It may be something like a damaging between the couple or between the individuals. It may be something that's seemingly as simple as, again, a damaging of property, constant telephone calls, so you want them to stop harassing, that may then ratchet up to the actual physical contact or the threat of the contact.
In your experience, how important are those protection orders?
I cannot underscore how important. The orders themselves are certainly important. It is the power of the court to issue them, but also to ensure that the parties who have to operate under them understand what they are and what the expectations are. Not just for the person that's seeking the order, the victim or the complaining witness, to say, I understand that you're here today and you're asking for this, so here is what the court's going to do to outline what the other party, the defendant, cannot do. And it may be a painstaking process to explain every single thing that they cannot do, but it's an important process so that the victim in the case understands what the limitations are. But the other thing is also to explain it to the accused, to the defendant, to say, here is what the court orders and expects you to not do throughout this entire time the case is pending. Because the other thing is that the protection order survives presumably throughout the life of the case. And it doesn't terminate, or it doesn't go away, and it doesn't change unless the court changes it. So there is no power of either of the parties to decide that the next week, if they want to be in love again, that they can just decide to ignore the order and go back to being how life was before. So you have to be really clear to explain to every person that's affected by it what they cannot do and what they have to do under the terms of the order, unless, again, someone violates it. And a violation of the order sometimes is a very clear signal of how, and that can be a clear signal of how someone may or may not respond throughout the life of the case. I think they begin by being effective by, first of all, ensuring that the accused clearly understands what it is that the order is and what it does. And again, it tells them things such as you are disqualified from carrying, holding, being in possession of a firearm, that you cannot call, text, or even use social media to contact the victim. Sometimes individuals don't even understand that if you say I can't have contact, or I am ordered to not contact them, that it may only mean I can't call you, or I can't pick up a phone, but now I can use Facebook, or I can use Twitter, or I can use a third party to reach out to you. And you have to be, as the jurist, you have to be 3 or 4 steps ahead of them in looking around that corner and explaining, this order now says that you can't even use a third party to do what I'm now ordering that you can't do yourself. So you can't use a substitute to get this done. And you have to be really effective in explaining that. One thing that the law does is the law tends to use language that common people don't use. So you have to speak in a language that the defendant clearly understands. It is not very effective, I find, to use legalese for someone who's now in a system that they need to understand in the language that they bring to bear. So you have to talk to them in the language that they understand. You've got to tell them, you turn off the utilities, even if they're in your name. You can't menace them, or you can't have certain types of contact or conduct with them. You can't go to their job. You can't harass them or call them at home. You can't call their family or their friends trying to get to them. And I find that these are terms and just verbiage, words that really cut to the chase of the person that's standing in front of you. Even if you would otherwise use a legal term to describe this, that this becomes really effective. The other thing sometimes is the power of the court to set bonds or conditions on bonds that further drive the point home, that says, okay, so even after I've set these conditions out in the order, I'm also going to make it clear that even after you've left my presence physically, there are some other conditions you're going to have to meet long after this that's going to provide safety for the victim and also protect your rights to make sure that we all get back here and resolve this matter at the end of the day.